back. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers a viewer's legal question on the air. First of all, good to see you again. Thanks for coming in.
Yeah.
Ready for the question?
I'm ready.
All right, here you go. What is the difference between a will and an estate plan?
Okay, great. Simple question.
Yeah.
Well, an estate plan is kind of an overall plan, and a will can be a part of an estate plan. But an estate plan can actually encompass a lot more than that, and usually does, because as we've talked about before, there's a couple reasons why we get into estate planning. One is we want to make sure that what we want to happen to our stuff happens. It goes to the people that we want in the way that we want it to go to them. Yeah. The other reason that we do estate planning is to avoid probate. Now, probate's not bad, but it is expensive, and it means that there are other people involved. So one of the reasons we're going to do estate planning is to avoid probate.
Right.
A will does not avoid probate. All a will does is it instructs the probate judge what you want to happen, how they're to distribute your assets.
Right.
So to avoid probate, we have to do something other than a will. Now, part of a good estate plan is going to have a will in it, usually what's called a pour-over will, because what other planning you do is the will is going to say, if I didn't make any other disposition for any of these assets, if I forgot something, then this is what I want to happen to the stuff that I forgot. So a will is part of a good, complete estate plan.
Okay.
But in addition to that, you're going to have generally one of two things. You're either going to have a trust, a revocable living trust. And a trust document is, it creates basically a container for your stuff.
All the stuff,
so
right.
Anything that has a deed or a title or like a bank account or a car, any vehicle, a boat motor,
is put into trust.
It's put into the trust account. And the trust then is the owner of that property rather than you, the person. And because it's a document that creates that trust, you can leave instructions to what's called a successor trustee, because you are the trustee of your own trust while you're alive. That way you can control the assets. Right. Just like you do when you don't have a trust.
But you appoint a trustee.
You appoint a successor trustee for the time you pass away, and then the trust document itself is going to explain to that successor trustee what they're supposed to do with your assets. That all happens outside of the probate system, so it avoids the probate cost. Right. Now, not everyone needs a trust. Okay, so
I can understand that.
You might be just too young. It's just not worth going through all the hassle of having a trust. You're still going to acquire property. You're still going to dispose of property. So you would use a different estate planning tool, usually non-probative transfers, non-probate transfers. Those are, Missouri has a law that allows you to title things, documents, bank accounts, with beneficiaries. So you can own your property in what's called a beneficiary deed. I can say, I own this property, but when I die, Tom gets it. He's the beneficiary of the beneficiary deed.
They're doing that a lot more with licenses and things for cars.
Yeah, that's called transfer on death, or TOD title. And it's the exact same thing. And for bank accounts, they're called POD, payable on death. Right. Now, the benefit to that is you still own 100% of that asset while you're alive, and your designee doesn't get any ownership interest until after you pass away. That's really important, because a lot of times what I've seen people do is they will say, well, I'm just going to put my kids on my bank account, or I'm just going to put my kids on my house, on the title of my house. Well, that comes with some pitfalls. First of all, I mean, if the kid's not trustworthy, they can take your stuff. Yes. Because they own a current interest in it. That's not usually the problem. The problem that people run into with something like that is if the child incurs a debt, either intentionally or unintentionally. Let's say they've borrowed a lot of money, and now the bill collector's coming to collect that bill.
Their name is on that account.
Their name's on the account. Their name's on the house. They may have the bill collector may have a right to seize that bank account and all the money in it, not just half, but all of it. Or they may actually be able to come in and force the sale of the home in order to satisfy that debt. So that's not good. The other way that people incur debt is unintentionally, through an automobile accident or other type of negligence. And even if we have insurance in place, if that insurance policy doesn't cover the total injuries, then you can be left with a judgment against the child that now gets satisfied by the assets of the parent because they put their name on the account. So don't do it. You don't have to do it.
Yeah, and if there's more than one, the others also pay the penalty in that case.
Absolutely, because it takes all of those assets away prematurely and leaves parents out on the street.
You know what I think I've learned here most, actually, is the fact that the do-it-yourself wills aren't the way to go necessarily.
There's a lot of guidance that needs to be given in this area. It's really important to get an attorney to do that.
All right, Will. Thank you very much. Appreciate it once again. Hey, if you have a legal question for Will, you can email him at wworsham@color10.com, and he will be answering your questions right here on the show. Always good to see you.
You too.
Get an attorney. That's what that said to me. Okay, coming up, we're going to talk about some simple ways to be smarter with your money during this week's Dollars and Cents segment. Stay with us.
Take advantage of Jerry's sale. See how? Call now.